everyone. Welcome to UCCJEA Child Custody Jurisdiction, Legal and Tactical Considerations. I'm Carrie Holmes, Pro Bono Director at the Harriet B. High Center for Family Law, and along with Ron Reichstein of Youngman Reichstein PLC, we are the co-chairs of the Family Law section of the BHBA.
Thank you to tonight's program chairs, Al Provinciano and Ellen Stein, for helping to coordinate this evening's program. Before we begin, a couple of housekeeping announcements. The materials for tonight's program were emailed to you in the 1-hour reminder email and are being posted in the chat. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that is included with your certificate. The Family Law section is sponsored by White, Zuckerman, Warsofsky, Luna, Hunt, LLP, and Our Family Wizard. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. They invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. I'm pleased to introduce Matt Havervold from Our Family Wizard to say a few words and to provide some updates about Our Family Wizard.
Thanks, Ron. Hi, everybody. My name is Matt. It's great to be here live. Our Family Wizard is the world's largest co-parenting platform. Our mission is to help families living separately thrive. We try to provide communication tools to help divorced and separated parents reduce conflict and stay organized with their shared calendars, uploading documents and files, and keeping track of shared expenses. For those of you who have been aware of Our Family Wizard for quite some time, we have had some updates more recently. We made a significant overhaul with the parenting schedule functionality on OFW. We did that about 2 months ago. And since doing so, the number of parenting schedules that parents are putting on calendars has more than doubled within the first week of putting that update out there. We also have some new updates with the way expense tracking works. If anyone's interested in seeing a demonstration of these new features, please feel free to reach out to me. My email is matt, M-A-T-T, at ourfamilywizard.com. I'd be happy to have a call with you. I also just want to point out for anyone that does any pro bono or volunteer work, we have a fee waiver where Our Family Wizard will be completely free for those clients. Thanks for having me.
Thanks, Matt. Thank you to our presenters this evening, and thank you to everyone in attendance. And with that, I'll throw it over to Ellen.
Thanks so much, Ron. It's my pleasure to introduce the panelists on tonight's program. First, Judge Goldberg, who briefly practiced business litigation before beginning a 16-year tenure as Deputy District Attorney for Los Angeles County, where he was involved in many high-profile prosecutions, including the Simpson case. He was appointed to the bench in 2003 and spent almost 6 years in criminal court and 10 years in family court. Among his assignments, he handled pretrial settlement conferences, assisting many of our clients in resolving their cases. The Southern California chapter of the AAML, Southern California chapter of the American Inns of Court, and Levitt and Quinn all have honored Judge Goldberg for his contributions as a jurist. Judge Goldberg is the author of the invaluable Keys to the Kingdom, California Family Law Findings, Orders, and Practice Pointers, and regularly posts updates on developments in California family law on his website. Currently, Judge Goldberg works at Signature Resolution in Los Angeles, where he focuses on family law matters. He serves as a mediator, arbitrator, judge pro tem, discovery referee, and parenting plan coordinator. Alphonse Provinciano is the founding partner of Provinciano and Associates, a Beverly Hills-based family law firm. Mr. Provinciano is a certified family law specialist and graduate of UC Berkeley and Hastings Law School. While handling a busy litigation practice, Mr. Provinciano makes time to actively serve in leadership positions in state and local bar associations. He currently serves as a member of the CLA Family Law Executive Committee and the Board of Directors of the Beverly Hills Bar, and is a recent past co-president of the Executive Committee of the Family Law Section of the Beverly Hills Bar. Thank you both for your participation on this panel. We have a lot.
Thanks, Ellen.
You're welcome. We have a lot to talk about tonight. So we're going to wait till the end of the program if we have a few minutes to take questions. Anybody who has questions, please post them to the Q&A and we'll see what we can get to. Before I turn this conversation over to the panelists to walk you through the jurisdictional analysis, there's a couple of things to think about as you're listening to this conversation tonight. First, consider tactics, including which jurisdiction's substantive law is most favorable to your client, not just legal and factual issues when conducting your UCCJEA analysis. Also pay attention to timing. When a child is out of state, prompt filing may be essential. However, as the panel discussion will highlight, timing can be a bit like Goldilocks' porridge. Filing must be not too late or not too soon, depending on the circumstances. Our job, of course, is to get it just right. Temporary emergency jurisdiction is just that, it ends. The jurisdictional analysis under UCCJEA is not necessarily intuitive. Don't jump to conclusions. Work through the statutory grounds for jurisdiction systematically. Now I'll turn it over to our panelists.
We're going to be working with a hypothetical throughout this presentation, so I'll read it to you. So in February of 2020, mom leaves Florida with a 1-month-old and a 1-year-old, and she goes to California to stay with family. She claims that there was an agreement that she was going to move out permanently and relocate to California. However, father claims that it was a temporary move and that he learned that she was not going to return only in July. He asserts that mom engaged in what's known as unjustifiable conduct, which is moving for the purposes of creating jurisdiction wrongfully in another state. Then in March of 2020, COVID strikes, and there's the shutdowns that we were all familiar with. In July of 2020, so this is 5 months after the move and before the younger child is 6 months old, mom files a DVRO here in California and for sole legal and physical custody pursuant to that DVRO request. She alleges physical violence in Florida and continued harassment thereafter and threats. And then she also files a parentage case. So again, this is before the younger child is 6 months old. Then in August of 2020, just under 6 months after the move to California, dad files a parentage action in Florida and asks for joint custody. I will be changing the hypothetical up a little bit, to add different dimensions to it as we go, but you might want to keep this in front of you for reference as we move through this presentation.
And in terms of UCCJEA jurisdiction, it's exclusive jurisdiction. And what that means is that it's the sole exclusive means for determining jurisdiction in custody disputes. And what that's really defined as is anything that's involving legal, physical custody, or visitation. So it's going to apply in marital relations cases, such as a divorce case. It applies in dependency cases, terminating a parental relationship, guardianship cases, parentage cases, and DVPA cases. So it's a catch-all that's gonna be inclusive anytime you're dealing in those types of actions with child custody. And it applies to states and other countries' orders that are in substantial conformity with the UCCJEA. And one thing that really comes up quite a bit is, can you stipulate to jurisdiction? And the short answer is no, because we're dealing with subject matter jurisdiction. You can't stipulate to it. The court, it's in some ways it's like a state of being. It has to have subject matter jurisdiction or it doesn't. And I would say, Judge Goldberg, if it's late in the day, you're finishing up your calendar, in our hypothetical, the litigants come before you and they bring you a stipulation saying that California is in fact the home state. What do you do with it?
My answer would also be the same if it were early in the day, but I still have 20 other matters. Calendars, kind of the same hypothetical. So, I'm just going to give you the practical retired judge answer to that question. We like stipulations. We like agreements. It makes our life easier. It narrows the issues. If I have two attorneys, they're experienced attorneys, it's an adversarial proceeding. They both say, we agree. We're stipulating California as the home state. Very likely that I'm going to say, thank you, stipulation accepted, and move on. Probably not going to ask a lot of questions or do any kind of cross-examination. Just say, okay, it's accepted. The problem is what happens down the line. So what happens later on when we really get into the thick of the litigation, and it occurs to me, as it will under this hypothetical, spoiler alert, that California does not have home state jurisdiction. You stipulated that California was the home state. I am now in a terrible quandary because I know that in fact, if I make any orders, those orders are not valid orders. And I can't in good conscience make the required finding that California is the home state. Also just point out another little practical aspect of this is, remember that as attorneys, there is a duty of candor to the court. That's they beefed up that requirement in Rule 3.3. And if you know for a fact, under no construction, under no possible interpretation of the facts, can there be home state jurisdiction? You shouldn't stipulate to it. More interesting issue is, what if instead of stipulating to the legal conclusion, you try to stipulate to the underlying facts, and the underlying facts are contested, as some of ours are in this case. So for example, what if it was contested initially? When did mom exactly arrive in California? And dad decides that he wants to litigate in California for whatever tactical reasons. And he stipulates, I'll stipulate that she arrived on XYZ date, the date that she said she arrived. That's a date that was 6 months before the proceedings, the petition was filed. Highly likely that that's going to be accepted. Highly likely it's not going to be subject to set aside. Or he wants to stipulate, you know what, upon thinking about it a little more carefully, she did permanently move to California, in fact, when she left from Florida. I'm willing to stipulate to that. The facts are contested. Highly likely that that kind of stipulation is going to be bulletproof and not set aside later on, either at the trial court level or at the Court of Appeal level. There is a one Court of Appeal case, though, this In Re JW case, which is kind of interesting, seems somewhat inconsistent with some of the other cases that we've read about and that we've cited here on this issue of stipulations and whether you can, through forfeiture, can you establish jurisdiction. In this case, they found that where no one said anything about jurisdiction at the trial court level, not the court, not the parties, there was no argument, no discussion about it, you couldn't raise the issue of jurisdiction for the very first time on appeal. So there is that one case out there that kind of puts a little bit of a question mark as to whether or not it might be possible to establish jurisdiction, at least through forfeiture or through some kind of waiver. So let's take ask a question then of both of our attorneys here, an attorney type question, and that is, let's say your client comes to you, let's say it's dad, and he insists, I want to litigate in Florida because I've never set foot in California. That's what I want. Or mom insists she wants to litigate in California. Do you just immediately run with that and say, okay, I'm gonna do it. That's what you want to do. That's the argument I'm going to make. Or are there tactical considerations that you need to take into account first?
Well, I think especially you want to consider some tactical considerations. And in this case, in the hypothetical, the father is unmarried, and California, as we know, is going to treat paternity, once paternity is established, they're going to give a little bit more deference to both parents. If he were to move forward in Florida, as we've cited here in our materials, that the Florida revised statute states that a mother of a child born out of wedlock is the natural guardian of the child, and is entitled to primary residential care and custody of the child. Now, I don't know how that's interpreted in Florida, because it does state that perhaps the court could enter an order otherwise, but father may really be setting himself up, if he's going to Florida, to really have a hard time, because it's going to be a presumption that the child is going to be primarily in the residential care of the mother. Maybe that's not what he's seeking. And also just interesting statutes that are very different from California. In Florida, for example, adultery is a misdemeanor. And Florida child custody law, as I was reading about it, states that mental fitness, moral fitness is a ground in Florida to decide custody on. So if you have a situation where one of the parties is having an affair, does that then affect their custody? So it may be one of those situations where stipulating to a disputed fact and having for father, it might be better. Ellen, how does New York law contrast, and what should you consider with that, for example?
Well, I think we always want to look at the law in any jurisdiction that we might have the option of keeping our client in, because the law does surprisingly differ in significant ways. So the New York statute talks about best interest of the child, which is the same thing in California. But when you look at what the courts have done, they consider factors which our courts have expressly said you can't consider. So for example, in New York, the courts are going to look at the respective finances of the parents, whether a parent can provide better educational opportunities, which is all about money. Whereas here in California, those kinds of issues are going to be addressed with a support order. And in fact, our court in Burchard expressly stated that those are not appropriate considerations. We can't look at the fact that there's a single mom who's working 2 jobs and the kid's going to be left in childcare, whereas dad can provide whatever the child needs and has a stay-at-home partner. One of the other things that New York courts will consider is whether a parent will be able to promote the children's religious beliefs and upbringing. Again, something that in California, we're really going to leave to the parents and to do what they're going to do in their household. So if I, for example, had a client who had significantly less financial ability than the spouse, I might not want to be in New York.
Would you both go so far as to look at things such as who is the individual judge that we're in front of? And what is the culture? I mean, some of the stuff isn't in the statutes, can't be found in the statutes. There's a culture in a courthouse that they handle a certain type of issue in a certain kind of way. And then how do you find that out?
I mean, absolutely, you want to know those things. And I think the best way to find it out is to speak to a local practitioner.
Okay, so in one slide here, we have covered all of the issues or the entire scope of issues under the UCCJEA. And a couple points. So as been stated before, one of these forms of jurisdiction is unlike the others. And that's temporary emergency jurisdiction. And we'll see that as we continue with this discussion, that first of all, it is supposed to be temporary, but there are other significant differences between temporary emergency jurisdiction and the other forms of jurisdiction that I have here on this slide. Next is initial jurisdiction. And initial jurisdiction is broken up into 4 parts. There's home state jurisdiction, significant connection. Other home states have declined, and at the bottom, default. And you do this as a hierarchy. You work your way from the top of the list, and then you may stop. You may end your analysis at home state jurisdiction and never get below that, because it's a hierarchy of jurisdictional concepts. So for example, we'll see in our hypo, as we get into that a little bit more, if the court does determine that Florida is the home state and not California, then at that moment in time, California would not reach the issue of significant connection. unless or until the Florida court had declined jurisdiction. So work your way from the top of the list down to the bottom. And then we have exclusive continuing. So that applies when someone has made orders based upon initial jurisdiction under the UCCJEA. Some court has made orders. And then if that's the case, then we can talk about trying to modify those orders and who and where will those orders get modified. So let's take a look then at the first issue of personal jurisdiction. How does that differ, Al, from these other jurisdictional concepts that I just reviewed?
Well, it's definitely something that people can get confused with, but personal jurisdiction under the UCC is not really, I should say, you can't confuse personal jurisdiction with the subject matter jurisdiction under the UCCJEA. And so it doesn't really have, they really don't have much to do with each other. And in fact, the court can make a custody decision without having jurisdiction over a parent. And that's page 16 in your cases and materials. Family Code section 3421C says that. And at page 58, it's in re marriage of Nuri, which, if you haven't read that case, is really got a tortured set of facts, which deals with kidnapping, armed guards, and Interpol warrants. But you know, it's something that if you're arguing a case from a tactical perspective, don't necessarily think of personal jurisdiction arguments when you're running through that hierarchy that Judge Goldberg has discussed, because they just don't apply. But Judge Goldberg, if for example, a client, in this case, perhaps the father in our hypo, is living in Florida and he says, I need temporary custody orders. I need to get some Zoom visitations or some brief visitations. Can he seek those in California in the context of temporary emergency jurisdiction without waiving his arguments over personal jurisdiction over him?
And the answer is yes. And there is a specific statute on it. And it's Family Code section 3409. There's also some case law. And it kind of makes sense that while we're waiting for the court to resolve this issue of temporary emergency jurisdiction, for example, dad might want some temporary orders. He may want to see the kids. He may want some Zoom contact with them or Skype or something of that sort. And by coming into court and making that argument, or even by physically appearing in court himself, he is not, based upon that fact alone, in some way conceding that California courts have personal jurisdiction over him.
And then that takes us to temporary jurisdiction, and basically, you know, what is temporary jurisdiction and when do you see it? And it's really, in a lot of ways, just what it sounds like. It's temporary. It has to come to an end, and this is really dealing with Family Code section 3424D, which places a requirement of the courts that they must immediately communicate if there's a case in another jurisdiction. And what practically you see this in is a domestic violence case. So for example, in our hypo, mother eventually at some point files a DVRO action and is going to seek temporary jurisdiction as a potential argument. And that's where this would come up the most, is someone fleeing a forum for domestic violence purposes and trying to get here and get some kind of temporary orders. But if there's a pending case in another jurisdiction, there's got to be a sunset time. And also there's a requirement that a evidentiary hearing is required on this matter. However, the Christian I case, which we've cited here, basically says that the court potentially failed to do the evidentiary hearing, and in that specific fact pattern, it was harmless error. And since this does come up in domestic violence cases often, Judge Goldberg, is there any practical way to interface with the DVRO forms that we see?
Yeah, there is. And as I'm sure you're probably fairly familiar with those forms. There's no real place on that form to indicate that there's some kind of sunset or limitation on temporary emergency jurisdiction. But remember, this would only come up if I knew that there was a pending case or pending matter in another court. Say, if I knew that there was a pending case in Florida in our hypothetical, which I might not know when I'm working through my stack of domestic violence cases that are presented or were presented at 3:30, and you need to get through the stack of 10 cases. But assuming I know that, then I would sometimes write in jurisdiction only lasts until the Florida court has acted in this matter, something to that effect. Just handwrite that in there. But I don't think that's a common or standard practice. And so if that hasn't happened later, at some later point, if you were representing dad, for example, you would probably need to bring that to the court's attention. Say, yes, there is a Florida case. In fact, they have a hearing, on such and such a date. We'd like you to set a sunset date for these temporary orders. Okay, so let's take a little bit of a closer look at home state jurisdiction. And again, as was indicated by Ellen in the introduction, these are not necessarily intuitive concepts, and the statutes, when you read them, are not that readable or easy to understand. You probably know that there are two forms of home state jurisdiction. That most people know that, but maybe it's a little unclear. Why are there two forms of home state jurisdiction, and what exactly is the difference, and when do you use one or the other? So one form of home state jurisdiction is when there's jurisdiction on the date the proceedings commenced. And then the other form of home state jurisdiction is there's jurisdiction within 6 months before the proceedings commence and the child is absent from the state, but a parent or person acting as a parent continues to be present in the state. So let's just give you a little bit of a memory hook to try to memorize this and clarify it. So basically, the first form of home state jurisdiction, if we're talking about California, is the kid is in California right now. And basically, the second form of jurisdiction is the kid already left California. That's the memory hook to help you remember these two forms of jurisdiction. Slight little wrinkle that makes it slightly more complicated than what I just said, but that's essentially it. So let's take a look then at the first form of jurisdiction, and this analysis applies to kids except for babies under 6 months, and we'll deal with them with children under 6 months separately. So let's talk about the child in our hypo that was a year old at the time that he left Florida. Is now, let's say, he's about 15 months old at the time that the case is filed by mom in California. Okay, so let's take a look at that child from dad's standpoint. Let's say dad decides he's going to argue that Florida has jurisdiction after he's looked at the tactical issues. Okay, so let's go through that. So did the child live in Florida with a parent or person acting as a parent? Element one, absolutely. Was that for at least 6 consecutive months, including temporary absences? Yes, there's no dispute about that. What about element number 3? The 6-month period was immediately before the commencement of the proceedings. Well, that we don't really know that from our hypothetical, because he's claiming that he found out in July that mom wasn't going to return, and so he's claiming that essentially she became absent from Florida because she was absent temporarily in July, and then he filed the case in August. So how much time exactly went by? We're going to need to figure that out. There is one case, the Scalorier case, that said that 28 days wasn't immediately. But exactly what does that immediately mean? I think in other contexts where statutes and legislatures have used terms that leave a little wiggle room, it's subject to interpretation. It may change from one case to another. Otherwise, they could have just said it's 7 days, right? But they didn't. So, for example, in our case, we have the overlay of COVID. So if Dad couldn't file a case in court, or he couldn't get to see an attorney, that should be relevant, perhaps, at least arguably, in determining whether or not he acted immediately. But again, if you're representing Dad or you're consulted to represent for Dad, you're going to want to make sure that you file that case as quickly as you can if you want to avail yourself of this jurisdiction. Now, looking at it from Mom's perspective in California now, well, right away we can see that element number 2 has not been met, because the child was not in California for 6 months before she filed her case. She simply filed her case too early in this case. She had waited a little bit, would have been much better for her. This is not necessarily, by the way, this 3-part structure immediately apparent from the statute itself. You also have to look at the case law, or I laid it out in my book, and the materials, all of which have been attached. So go through that and just go through it element by element by element. It's the only way of doing it. So now let's look at the second theory of home state jurisdiction. Again, this is again for babies that are less, does not apply to babies that are less than 6 months. And this applies to children who are absent from the state. So let's take a look at this from Dad's perspective and Florida perspective. So did the child element 1, previously live in Florida for any consecutive 6-month period? Yes. Now, after the petition's filed does not count. It has to be before the petition's filed. Although in domestic violence, if all you did is file the domestic violence case, as Mom did in our case, you could still consider the time that elapsed after the domestic violence was filed in determining whether she reached her 6-month period. Okay. Did the 6-month period end within 6 months of Dad filing his case? Absolutely, because that's right in the hypothetical. Now, he came in just under the wire. Had he waited a little bit, it would be a different scenario, but he got it in just under the wire before that 6-month period elapsed. And then is third, is a parent or acting parent continuing to live in the state of Florida? And the answer, we'll say the answer is yes. But if he moved from Florida, if he's no longer in Florida at the time that we're making this decision, then this theory wouldn't apply either. But under our facts, yes, this applies. Now, does it apply to Mom and California? Can we argue somehow that California has home state jurisdiction under the second theory? Let's just go through systematically, but I'm going to skip to save a little bit of time to element number 2. Once again, we see is missing because Mom filed her case too soon. If she'd waited a little bit, she could have made that argument that California was the home state. So that's the analysis of home state.
And taking a look at babies, it's obviously less than 6 months. It's where it gets a little dicey because there's a little bit more of a gray area there. So in this hypo, and as Judge Goldberg mentioned, if Mom had waited just a little bit longer, maybe you don't have to go through this analysis of what to do with the baby, but she didn't, and we have to kind of deal with a baby. So what it really goes to with a child under 6 months is, and you think, aha, this is easy. It's the state where the child lived with the parent or acting parent from birth. And in our cases and materials, section 1.1, that's at pages 7 and 8, has a really, it's the keys to the kingdom synopsis, goes through all of the cases that deal with how do you look at what's the definition of living. The one particular case is In Re Baby Boy M, which is at page 92. And in that case, what you have is that you have a baby that is born here, stays here for 2 days, and then goes to Georgia. and the court ruled that didn't qualify as living in California because it was so incidental. And that's where we have where born except in a temporary hospital stay doesn't qualify. You have to contrast that at page 105 of the materials with the Asagueda case. And I hope I pronounced that correctly. But in that case, it's kind of interesting because the mother has her whole life here in California. She has her job, she has her relationship, etc. And then she moves back to Hawaii, gives birth to the baby in Hawaii, and lives there for 6 weeks. Then comes back to California, and dad files a petition within a day, and the court ruled that didn't constitute living here because everything was really in Hawaii. This whole child's life was in Hawaii, and it didn't count living here. So really, sort of the moral of the story in dealing with cases involving babies, if it's dad's case in our hypothetical where he's in Florida and he wants to have UCCJEA home state jurisdiction in Florida, he's got to act quickly. And that's really the tip and the practical aspect of this is moving quickly to get his petition filed. And of course, he could argue, and we included the Serene case at page 99, that potentially time spent in this forum doesn't count towards the 6-month period or doesn't count towards jurisdiction. But he's got to move fast. And for mom, really, if she had just waited a little bit longer, so maybe come quickly, determine if she needs to move forward or not, but then maybe the best thing for her to do is to potentially hold off in what she's thinking. So that takes us to a kind of a nice move to our next slide, next topic, which is significant connection jurisdiction and unjustifiable conduct. And so when you're dealing with this, what the key statutes that you're going to be working with is Family Code 421A2 and Family Code 3427. 3421A2 and Family Code 3427 and 3428. But what you're really dealing with is a situation where one state may be, if you're seeking a significant connection, that it's California has more of a significant connection with the child than another state. Maybe there wasn't a reason to go forward in the other state, but in California, for example, with the baby in this case, that the child spent 80% or more of their life here in California. And often in unjustifiable conduct cases, domestic violence is a pivotal issue in it. And Judge Goldberg, when you're looking at the significant connection jurisdiction, when you're looking at unjustifiable conduct, in the era of COVID, what arguments and evidence are particularly applicable for significant connection cases?
So let me just say that I do think the argument that mom has, that particularly on the younger child, we know that at least 4 out of 5 months of that child's life were in California. And by the time the ruling rolls around, it's going to be even more than that. That's a really good argument. And even for the older child, let's say the older child's 15 months, it spent the last 5 months in California, but that older child probably doesn't even really remember much of what happened or little of what happened when they were in Florida. They certainly don't have much of a recollection or connection to what happened when they were 9 months old. So the primacy of that experience in California is a strong argument, I think, for mom. Having said that, so what could you argue if you were representing dad? Well, the COVID does put a little bit of a different spin on this, because now dad gets to argue, okay, that's true. She did spend the last 4 or 5 of the 5 months with the children here in California. but she spent it locked up, essentially quarantining in an apartment with with the kid's grandparents. And the apartment happened to be in California, but it could have been on Mars. They didn't go out of the apartment. They didn't do mommy and me classes. They didn't do preschool or daycare or any of the normal things, or play dates, any of the normal things that kids do that might connect them to the community. So this COVID opens up an interesting area of argumentation for dad in this hypothetical. I would just also say that on all of these issues, credibility is going to be very important. And there are factual issues and disputes between the parties. They just have a different scenario as to what they're saying happened on some of these issues. And I always say that, credibility is like virginity. And once you lose it, you don't get it back again. So, if the court finds, what, dad or mom, you willfully testified falsely on this one issue, as the laws, the court can then, or the trier of fact can then take a disregard or reject anything else that they said on any other issue, unless the probability of truth outweighs the probability of falsity. And finders of fact do that a lot. The other thing that you should ask yourself in working your way through these issues from a factual and tactical perspective is think a little bit, if X were true, what else would be true? And X being the fundamental core premise of the case. So for example, dad's premise in this case probably is going to be something like, oh my gosh, mom kidnapped the kids. She went to California and she didn't have my permission and she stole the kids from me. Probably a very hyperbolic, recitation of the facts. Okay, well, if that were true, what else would be true? And if it were true that he only learned in July that she was staying in California permanently, what else would be true? So what else would be true is he probably would have taken immediate action, maybe by immediately seeking legal advice. What else would be true is there would almost have to be text messages and emails in this hypothetical, especially with people who are younger than I am, and that's how they pretty much communicate. And you can almost hear the cross-examination, at least I can, of dad. So dad, how did you feel when you learned that she, in your words, kidnapped the kids in July? Oh, I was devastating. A piece of my heart had been ripped out and stomped upon. So you immediately sent an email, right, to her saying, gee, you don't have permission to be outside of the state of California. You need to return immediately. No, it didn't really occur to me to do that. Oh, but you sent a text message. Oh, no, I didn't send any text messages. That's going to be hard to explain. If that evidence doesn't exist, he's going to have a lot of explaining to do. And if you're representing him, you're going to need to explain that to the judge. Why didn't he do the things that anyone else would have done if the scenario that he's presenting was in fact the truth? We can do the same exercise for mom. I'm not going to do it now, but as an attorney, you need to do that same exercise with both sides of the case in order to analyze it, prepare it, figure out your cross-examination, figure out your direct examination, figure out the arguments that you're going to make to the court.
And another area to consider for going through the jurisdictional analysis is if other home states have declined. So if any other would-be home states decline jurisdiction, it might be because they deem that California is the more appropriate form, or that there was unjustifiable conduct, which is, we're talking about more of the sometimes going to a forum and forum shopping or domestic violence issues. But in reality, you don't really see this come up all that often. I know for myself, for example, I have only seen it one time where the Arizona court declined jurisdiction because it clearly had jurisdiction over one child, but it didn't have jurisdiction over the other child. And so it deemed that it was a more appropriate form for both kids to be in the same court. that might be one area that you see where a home state declines it. And obviously, from a tactical perspective, if you perceive that that's an issue, you want to somehow play that into your brief, and then as Judge Goldberg will talk about, somehow if there's a way that you can make sure that this is a topic of conversation at the UCCJEA Judges Conference through your briefing or some other method. And then finally, we're dealing with default jurisdiction. And practically, this is here as a placeholder. It's really where no other state court has jurisdiction. So you'd have to go through everything else, and that there's got to be some kind of a default jurisdiction catch-all in case there's no other state or jurisdiction that would somehow meet the criteria of home state or significant connection or some other state declined. But in the practicalities of things, you don't particularly see that there. Now, Judge Goldberg, could you tell us a little bit about continuing jurisdiction, since this is really a topic that comes up quite a bit?
And this is probably one of the most, or the most complicated finding and conclusion I have in my book, which just happens to be in this presentation. You'll read it. So, oh my gosh, because I try to make everything as simple as I can and break it down in all of the legal concepts into constituent elements. This one is hard. And in working your way through, if you use my materials, just cross out everything that doesn't apply to your case. And what you should be left with is then the correct analysis and ultimately the correct order that the court should make in that case. Continuing jurisdiction only arises where some state has made custody orders. Now, the decree state is defined as a court that properly acquired initial jurisdiction in substantial conformity with the UCCJEA and was first in time. That's known as the decree state. Let's think about that for a second in our hypo. Do we have a continuing jurisdiction issue in our hypo? No. We say, well, wait a minute, but there were orders. California made orders pursuant to the domestic violence protection orders. Those don't count because they weren't based upon initial jurisdiction. They were based on temporary jurisdiction. Again, hearkening back to the theme that those temporary orders are distinctively different from other orders that are made under the UCCJEA. But let's change the hypothetical a little bit. Let's assume that not only did Dad file his case in Florida, but Florida actually made some orders. They made orders, and they made orders because they found themselves, they were correct to be the home state. Now we have an issue. Now we have an issue of continuing jurisdiction. So the law is that decree state, so Florida in the hypothetical, would continue to have exclusive jurisdiction until there is a judicial determination of one of two things. So there has to be a judicial determination, and there are two possibilities that could then result in Florida no longer having exclusive continuing jurisdiction. The first is the decree state, in other words, Florida in our hypothetical, could conclude that it no longer has a significant connection with the child or a parent or acting parent, and that substantial evidence no longer is available concerning the child's care, et cetera, in Florida. So if the Florida court made that decision, then it would, in essence, have divested itself of continuing jurisdiction. The case law says that if a parent still is in the decree state and they're exercising visitation in the decree state, and the parent-child relationship has not deteriorated, then jurisdiction would then remain in the decree state under that first method of divesting the decree state of jurisdiction. The second way that the decree state could be divested of jurisdiction, this is number 2 on this slide, is that the decree state, either Florida or another state, California, either state, could conclude that the child and the parents or acting parent do not presently reside in the decree state. And the judicial determination must be made when the child and parent are absent. So in other words, if let's say that we change up the facts again a little bit, and Dad is no longer in Florida and has left Florida for good, and I'm the judge, I'm still sitting, and I'm ruling talking about, so well, wait a minute, dad's not in Florida, right? And he left Florida and the kid left Florida and mom left. In fact, no one's in Florida. They've all abandoned Florida. In the course of saying that, I have now divested Florida of jurisdiction in essence, because that constitutes a judicial finding that no one is in the decree state, and therefore Florida doesn't have continuing jurisdiction. There are no specific magical words that I need to use to make that finding. Now, let's look at the next related concept of modification jurisdiction. So modification jurisdiction only comes up if there are other orders from another state. So let's say, again, there are other orders. Florida's made orders. Let's say that they even resulted in a final judgment in Florida. And then years later, you know how family court cases don't end. Everyone's left Florida. And now dad's in California, mom's in California, the kids are in California, and they're still fighting, believe it or not. So here's the analysis for modification jurisdiction. I have to start out by going through the analysis I just went through on continuing jurisdiction. So that's the first step. I have to do the analysis I just did. And I conclude, you know what? Step one, Florida no longer has exclusive continuing jurisdiction because I am concluding that everyone has abandoned Florida. No one's currently residing in Florida. Second, the second step, I must then find that California has home state or significant connection jurisdiction. So now I have to make a finding. Yes, California has jurisdiction. And then third, one of two things has to happen. The other state, meaning Florida, has to determine that it no longer has jurisdiction, or that California is the more convenient forum, or California or the other state determine that the child and a parent or person acting as a parent do not presently reside in the other state. So let's say, Al, that I've gone through this analysis and I've concluded, okay, Florida no longer has continuing jurisdiction. And I do. California does have jurisdiction. What's the procedural mechanism to tee that up and get that modification issue in front of a California court?
Right. I mean, that's when a client like this comes into your office, you scratch your head for a second, you say, what do I do to get this to a judge? And so there's a couple petitions that are really applicable here that you can file a petition in an RFO, and I'll talk about that in a sec. So you would want to file possibly a notice of registration of an out-of-state order. And that typically the clerk is going to mail that to the parties, and that constitutes service. I think the best practice, though, is still, because it's a official proceeding, is to personally serve that. And then you could file one of two petitions also. You could file a petition for custody and support, and you can cite the out-of-state order. Or you could potentially file a petition for parentage, although there might be reasons why not to do that if parentage has already been established, as it would be in another state. Whichever way you go, then what you've got to do is you have to file an RFO seeking the court to make a determination that it has modification jurisdiction, and then it can make the findings that Judge Goldberg referenced, and then at that point you can seek a custody modification. So we're talking about things that can be timely and difficult depending on how far out RFOs are set, but it's that would be the best. Those would be really the best and only options you have. And I know, Judge Goldberg, something that everyone wants to really know about is what really happens in a UCCJEA judges conference, and what's the procedure, and how should they contact each other?
So it kind of takes me back to when I was in the family law judicial overview course, which is a really great week-long course. But the two things that I found most mystifying in the course, one was, and I said, how do you figure out what a permanent spousal support order is? What's the dollar amount? The answer to that was you use your discretion. So, not too helpful. The other thing I found mystifying is what goes on in this required conference between judges where there are two potential states or two states with open cases, because it's so foreign. It was so foreign to me coming from a criminal background, because it almost kind of smacked of maybe being an ex parte type of proceeding, but it's specifically authorized. So here's how that looks. So if there's a proceeding in another state that has jurisdiction, for example, and I have my case and Florida has their case, then the steps are I'm supposed to stay the California proceedings if I've determined that the other state has home state jurisdiction, and then communicate with the other court. There has to be a determination as to which jurisdiction is the more appropriate forum. But again, that determination is going to be made in our hypo by the Florida court. And if the other court does not determine that California is the more appropriate forum, then our case in California would be dismissed. So here's the procedure. The parties can participate. Some judges will do this in open court with the court reporter, and the other court is on the phone, and maybe even dad's sworn in as a witness in Florida, mom's sworn in as a witness in California. But it doesn't have to be done that way. But there does have to be an opportunity for the parties to argue about the jurisdictional issues and what should take place before that conference takes place. So here's how it might look. I might have a hearing in my court where I say, okay, dad and mom, I'm going to give you the opportunity to argue what should happen in this judicial conference, what should take place. And I might have some questions like, well, mom, what is your argument that California is the home state? Well, I almost filed it within 6 months. Okay, thank you for sharing. That's not a good argument. Okay, so you don't really have it. But Your Honor, I think that California has is the more appropriate forum for this to take place. That could be true, but that's for the Florida judge to decide, not me. Okay, so we'd have that conference. Okay, Dad, what's your position? What do you want me to talk about? So we'd have that little argument, probably in open court, so the parties would have an opportunity to address what should take place. But then after that, maybe the same day, maybe another day, maybe a week later, I might have a conference over the phone with that Florida judge, and that could look something like this. I might say, gee, Florida judge, I've looked at this. I don't really see how California can be the home state. What do you think? Yeah, you're right. California can't be, Florida's the home state. I agree. Okay, but mom's been arguing that she thinks that California is the more appropriate forum, but I think that under the UCCJEA, you have to decide that. Gee, Goldberg, you really want to pawn all the work off on me, I see. But you're right. I think you're right. I have to make that call. So here, the Florida judge says, here's what I'm going to do. I'm going to set it for a hearing. We're going to hear out the arguments about appropriate forum or wrongful conduct, all of the arguments that mom wants to make about why California is the appropriate place, forum nonconvenience. I'll advise you as to when that's going to take place. Of course, I'll advise you of the ruling. And that would probably be the end of that conference. Now, then I would go out to my clerk, because this doesn't have to be on the record. And I might say to my clerk, because I do have to make a record of it, it just doesn't have to be with a court reporter, summarize to my clerk, here's what happened. I had the conversation, this is what I said, this is what the Florida judge said, here's what we agreed to do. He's agreed that he's going to have a hearing in Florida and will advise me of the result of that hearing. So that's kind of how that would look. A couple interesting cases on this. There was one case where the court sent a couple emails and made several telephone calls to Mexico because they thought that Mexico was the home state. The Mexican court and authorities never responded. And the Court of Appeals said, not only did that comply with the requirement for the judicial conference, but those facts also justified a finding that Mexico had declined jurisdiction. Other interesting case. There was a case where the California court finds that Japan is the home state, attempts to call the Japanese court. They were as confounded by this procedure as I was before I took judicial training. They thought this was an inappropriate ex parte conference with one of their judges. They refused to participate in it. And the Court of Appeal held that the refusal by the court in Japan to participate in the judicial conference, in fact, was compliance with the requirement for a judicial conference. So if the court can't do the conference, it may be something that can easily be worked around.
So in conclusion, one of the things that's clear is that timing can really make a difference, particularly in determining if the party has home state jurisdiction. As we've discussed in the context of the hypothetical, mom jumped the gun in filing her paternity case, and dad likely was too slow in filing his, although we're unclear what the facts are. So when a client comes to you, you have to be very aware that if a child is out of state, you may need to file a petition immediately. But we don't have complete guidance on that from the statute. We do know from In Re Gloria A that in the facts of that case, 28 days was not immediate. But we don't know specifically, because the statute doesn't define it, what immediately might be on the facts of the case the client brings to you. Especially if you're going to decline a case, you want to make very, very clear to the client in writing of the need to act timely and what the dangers are here with the timing of a filing. This is not an easy statute. It doesn't give you a chart that you can follow and work through. If not X, then Y. Judge Goldberg has given us a tool which is contained in the attachments to your materials. And as he suggests, you can use that and cross out the facts that don't apply to your case as a way of sorting through the analysis. Even still, if you're new to custody jurisdiction issues under UCCJEA, it's not a bad idea to identify an experienced practitioner and ask for help and consult if you need it. Finally, jurisdiction may be possible in more than one state. And when that's the case, you want to evaluate which state's substantive law is more favorable to your client. I think we often tend to opt for California because we're more comfortable with the law, we know it, or because we're chauvinistic about our state and our law. But it may not be what's best for our clients. Again, a consultation with local counsel is going to be invaluable, because as we've discussed, what the statute says on its face is not often going to give us the full picture of what a court is going to do or what a particular judge is going to do. I am not seeing any questions. Wait, I'm seeing. Nope, I'm not seeing any questions, and we've hit our time. So I want to thank Judge Goldberg and Mr. Provinciano for all their time and effort in preparing this program. And I also want to thank the folks at the Beverly Hills Bar for their support in making this program a success. Thank you all.